Every problem has a solution, and every conflict can be resolved peacefully if the parties are willing to explore a negotiated settlement. Although legal disputes tend to spawn costly litigation wars, they no longer have to. Court-connected mediation, a process by which a neutral third party is engaged to help the parties resolve their legal disputes, is now an option. On the 6th of November 2013, the Supreme Court of Belize introduced court-connected mediation as an alternative dispute resolution option. Many other countries have instituted this program, and statistics have shown a 60% success rate. Let's meet the key players. The Mediation Committee. The Mediation Committee was formed under the direction of the Chief Justice and is chaired by a Supreme Court judge. Stakeholders from various sectors of society sit on this committee to oversee the entire mediation process, from the rules to the training of the mediators. The judges. The judge's role is to assign cases to mediation. This can occur at any point of the case, as long as the judge has considered the following factors. 1. The nature of the dispute. 2. The willingness of the participants to resolve the dispute. And 3. The relationship of the parties. Note, however, that the following cases are not assigned to mediation: criminal matters, non-contentious probate matters, insolvency matters, and family matters. However, the judge may decide not to refer the case to mediation if a good reason is shown. The Mediation Coordinator. The Mediation Coordinator is responsible for managing the logistics concerning all mediation affairs. The Mediators. The mediator's job is to serve as a neutral third party in the mediation. The mediator assists the parties with settling their disputes.
Good morning, and thank you both for choosing mediation. Mediation is a party-driven process where you both have an opportunity to come up with a solution that's going to work for you. This is a claim brought by Capital Meats against Everfresh Supermarket for $80,000 which have not been paid for meat supplied to Everfresh Supermarket. You will both have an opportunity to explain your own problem, your own points from your own perspective.
It should be noted that all court-connected mediators are required to successfully complete the Supreme Court's training program for mediators. Appointed court-connected mediators must abide by a code of ethics and may be disciplined for non-compliance with the standards set for mediators. The parties, you the litigant. The role of the parties is to show up to the mediation with an open mind, respect the process, and be willing to discuss the problem.
I have been trying to get my money for 8 months, and they're giving me the runaround.
Our business have a reputation for selling the freshest meat. Imagine the embarrassing situation having to receive our meats on Christmas Eve. When we called to complain at their office, their supervisor had the nerves to say, "We tired of hear hard time story just to run for we money."
What? I'm so sorry they were rude to you.
The lawyer. Lawyers do not have to attend mediation sessions, but where they do attend, their main function is to provide advice to the client during the mediation session.
Now that we're clear and agree on the issues, what are your ideas of what can be done to help resolve the situation?
So what are the benefits of this process? And why would parties want to use mediation? Well, there are many benefits mediation has over litigation. Privacy. Mediation sessions are held in private, as opposed to matters in courts which are open to the public. Cost. Mediation sessions take less time and money, while litigation is usually lengthy and costly. Empowerment, control, and outcome. Parties determine the outcome of mediation, while in litigation the judge makes the decision which may not be acceptable to the parties. Relationships. Mediation focuses on preserving the relationships, as opposed to litigation, which tends to be more adversarial and often damages relationships. Compliance and enforcement. Parties usually comply with agreements when they play an active role in the decision-making process, while in litigation, enforcement proceedings in the court can oftentimes become another long, drawn-out process.
Well, I must congratulate both of you for coming to an agreement.
But what happens in instances where no agreement was reached or only a partial agreement was reached? The matter is then referred back to litigation.
Well, I want to wish you both success in your future endeavors.
Mr. Mediator, thank you. Who knew we could have resolved this in 2 hours? We would like to supply you with meat this year, if you would let us.
Sure, Ms. Acosta. Let's work on building back our business relationship.
Thank you.
For more information, please visit the court's website at belizejudiciary.org.